Yes, Assistant.
Ladies, my lords, dealing first with the family rights group, we're not going to have very much to say because there's a considerable measure of agreement and even you might say mutual support here. Clearly, Hackney is fighting this appeal, of course, but beyond that, in its responsibilities, we all have broadly the same interest in clear guidance and knowing where we are. So we can only endorse that, of course. So no quarrel at all. And as the family rights group correctly says, we agree the position in relation to the effect of statutory guidance under Section 7 of the Local Authority Social Services Act, but we made the point that here, for this appeal, we're dealing with the statutory guidance as it stood in 2007, which was sparse, really, on this issue, to say the least. So we've no more to say about that. We'd just like to comment briefly on what was said about paragraph 79 of our written case, which is at page 2803. Just because it might be thought, if one just looks at it in bare terms, it might be said that we're adopting a rather restrictive attitude. But it's important, perhaps, first of all, this whole passage, which begins, of course, it begins at 2 or 3 pages earlier. I'm not going to go right back to the beginning at paragraph 64, but this is all under issue B. This is on the footing that the local authority is required positively to obtain consent, which is of course not our case. And where we say that once a social worker correctly assesses parents as having capacity, there should not be additional duties of full information and fairness by the persons, provided the persons with parental responsibility understand they're agreeing to their children being accommodated by the local authority. I just really want to stress duties there, because we've been here to deal with questions of duties. Of course, we're not suggesting that there shouldn't be fair discussion and fair information given in the circumstances.
But that's why I'd quite like to see the leaflet. You're going to produce the leaflet because you.
Yes, well, we haven't got it.
No, because I mean it's important to distinguish between issues of administration or maladministration, on which the Ombudsman has found that you fell short in terms of information and you had to correct it by producing a leaflet, and issues of law. And so on issues of law, I understand your case is you don't have to show consent. But I think as a matter of practice, you may well say that it would be a good thing to have informed consent or written consent, do you?
Well, in practice, my lord, well,
I was hoping the leaflet might show me. Am I going to see the leaflet?
I'm trying to get it, my lord.
No,
the answer is, I don't know, my lord, until I've got it to produce to your lordship. I haven't got it at the moment. We're trying to get it.
Thank you.
It'll do later, I'm sure.
Yes, I don't mind.
Yeah.
I'd like to know whether I'm going to get it sometime.
No, you will certainly get
Well,
it,
if my lord gets it, perhaps the rest of us can.
that goes without saying, my lady. We're not discriminating positively in Lord Carnarvon's favour or depriving the rest of you. So, no, of course, we'll produce it as quickly as we can for the court. Yes, on that, of course, and in practice. And I would like to stress in practice, for example, this case, getting the agreement in circumstances where you got to the way the guidance was being applied by us, the Coventry guidance, and getting an agreement. This agreement got to be obtained pretty quickly and we did use what is accepted to be basically a standard form in circumstances where we know and we acknowledge that the parents naturally were in an emotional state, and in this sort of situation where, dealing specifically with this situation where it's our position that the parents do not have the right to object under subsection 7, it's not an easy situation, because there, if the parents are in fact objecting, but they haven't got the right to object, then clearly it's not going to be an easy situation to deal with. But we're not suggesting for one moment that there shouldn't be discussion and there shouldn't be as much discussion of the situation as can realistically be managed in the circumstances. We're simply, at that point, we were simply dealing with, importantly after all on this appeal for us, what our actual statutory duties, responsibilities are. But we welcome guidance. And just to stress that this case, after all, did involve, I've said before, it involved a high degree of cooperation, as it happens, but against and inevitably, to some extent, constrained by the fact that the background was serious allegations against Mr. Williams, which persisted throughout the whole period we're talking about. And yes, they were for perfectly obviously sound, good reasons. The prosecution was dropped at some point, but the judge made the finding he made as well. So it's the picture of some sort of non-cooperative approach by Hackney in this case, which is wrong. We were doing a lot in very difficult circumstances. So far as the ALC are concerned, it's clear, and we accept it's perfectly clear, that local authority accommodation under Section 20 does not extinguish parental rights. That's absolutely clear, and there's no possible argument about that. Of course it doesn't. We don't want to go to the case right now, but the Tameside case, which is in the bundle, it's number 6. It's in Authorities Bundle 1, and it's tab 6. The Tameside case, we don't go to it, but that itself, that was a case where the parents objected. The local authority were accommodating the children, and they wanted to change the foster parents, and the parents objected to the change of foster parents, and their objection was sustained. But why we mention that case is because it's not, in a sense, necessary for our case on this appeal, but it actually gives quite a useful indication of where the lines are drawn between those aspects of the exercise of parental responsibility, which just inevitably go with the fact that the children are with foster parents usually, they are in local authority care. Of course, all sorts of day-to-day ordinary aspects of the exercise of parental responsibility have got to be carried out by the foster parents, got to be carried out, in effect, by the local authority, but through whoever has actually got the children day to day. But then there's some line, and the Tameside is an example of that, where the continuing and retained parental responsibilities of the parents kick in, and they get to make the decisions. So there's no problem about that point. But the parental rights issue doesn't in the slightest undermine any of the submissions we've made. And I don't want to repeat the submissions really, but it's the nub of our important submission on Section 20, subsection 7, is that Parliament clearly has intended a person with parental responsibility in some circumstances to be unable to block, if I use that word, the local authority exercising its duty, performing its duty under subsection 1, or exercising its powers under subsection 4. And simply say that actually subsection 7 deals more satisfactorily with those cases where, for example, there is a person with parental responsibility, but they can't be found, or they could only be found with some difficulty, or there's some doubt about their whereabouts. And also, we'd suggest the incapacity case, because subsection 7, we'd say in the end, perfectly sensibly, it requires, or it allows for an objection by a person with parental responsibility, as long as they satisfy the other requirements of subsection 7. But of course, it's been our submission, and I don't want to bang on about it, because you've heard enough of this submission, that what's not required beyond that is consent, which is more difficult then, raises all sorts of more difficult practical issues. We, as far as the comments, moving on to a different point, which is the comments made by Lady Black in Re B. Which is tab 18 in Authorities Bundle 1, and pages 361 and 362. We've actually said what we've got to say about paragraph 34 of that judgment. just a comment was made on behalf of the ALC in relation to paragraph 35, which we mentioned in the past. And Lady Black said, to return to my analysis of section 20, one possibility is that, as the local authority argued, the duty arose under section 20 because Kay's care at home was such that she wasn't needing, and section 21C applied, because the people who cared for her were prevented from whatever reason from providing her with suitable accommodation and care. But secondly, the local authority was prevented from fulfilling that duty by subsection 7 as the parents objected. And the alternative was that the joint effect of 21 and 27 was to prevent the duty arising at all. And the either way, and we said we don't need to make submissions about which is right or wrong. If we had to make a choice in terms of submissions, we would go for the second, but we don't have to, because the either way is correct. In that situation, the local authority could not have provided Kay with accommodation under section 21 at any time. But of course, in our situation, we say that they were not just entitled, but bound to do that. It was suggested that there were difficulties, or that judicial review proceedings were inappropriate or unsuitable. We don't suggest that there may be issues which, in practical terms, may be more effectively explored and dealt with in care proceedings than in judicial review proceedings. We can't really dispute that, but without going into that, in the end, that isn't the point, because, and it follows from submissions we've already made, that, for example, we've discussed the example where the parents challenged the local authority's assessment of the word able under section 20, subsection 7. And judicial review we suggest that's one way of dealing with it. It may not be a perfect solution, but what we do say is that even if in certain circumstances in relation to certain questions, and this ties in with the comment made by Lady Black in that other paragraph in Re B, whether or not there may be circumstances where care proceedings could then fully explore issues which possibly on judicial review are dealt with in a different way. There's nothing whatever in that comparison of the efficacy of those two types of judicial proceedings which can come anywhere near enough to displace the arguments which we have put before the court as to the interpretation and the effect of subsection of section 20. Mr. Sinai reminds me that under judicial review proceedings, it is possible for the court to give directions to issue care proceedings in the family court. So that's an extra. Thank you. That's an extra possibility. I'm not sure if we say, not sure we fully understand the significance of a supposed distinction between the parents having the right to object under, moving at a different point, right to object under subsection 7 and actually objecting. Our submissions really proceeded on the basis that if you do object when you are not within the category of objectors under section 20, subsection 7, you don't have the right to object. So you objected, but your objection, I don't want to put this too dismissively, but in terms of the section, your objection counts for nothing because you are not within the category of people who can't object. That category being those who are either not willing or not able. So, my ladies, my lords, those are our responses to the two sets of submissions.
Can I just ask you one point? We've now got section 21 of the
yes.
89 Act, which is provision of accommodation for children in police protection, which hasn't been relied on here. Just I'm wondering why it's not applicable in the facts of this case.
Well, it was applicable. It was applicable
for 72
the duration
hours.
of the police protection order, which was for 72 hours.
Yes. It would have worked for 72 hours, but
I see.
But after, exactly.
It's not applicable thereafter.
No, I see.
if any of your lordships have any further questions, I'd invite Baroness Hale to answer them for me. So, but subject to that.
I'll take that up later.
No, thank you. But so those are,
Anyway, so
those are our submissions, my lady.
Thank you very much. Thank you.
My lords, my ladies, we have relatively few matters to come back on by way of our response. May I deal firstly with the issue, or an issue raised by my Lord Wilson this morning, a question that was asked of the ALC as to what the appropriate action or remedy is if a parent presents, for example, at the home of the foster carer and seeks to action their entitlement under Section 28 to remove the child. To some extent, this has been dealt or addressed by Mr. Justice Munby in the decision of Nottingham, so it might be helpful to look at that, and that is in Volume 1 of the Authorities, MS 226. It is tab 10. We looked at this authority yesterday, but there is some consideration in this judgment of what action a social worker or a medical professional or any other person might be able to lawfully take to safeguard or protect a child. And it assists us to some extent in relation to the question my Lord was asking. First of all, it would seem that in circumstances, well, it is clear from the Act that in circumstances where a person has a care of a child, as a foster carer would, they are acting under Section 3.5 of the Act. So they are a person who does not have parental responsibility for a child, but they would have care of the child, that child having been placed with them by the local authority, and in order to protect that child from a risk of harm, if a risk of harm is present from the parent attending at the home, then it would seem that they're able to take or to do what is reasonable for the purpose of safeguarding or promoting the child's welfare. But that is a very short-term solution. That is an immediate solution. My Lady Hale observed during that discussion with Mr. Toomey that, of course, the question in terms of an application for an emergency protection order, which would be the immediate short-term legal route to prevent removal, would depend on the threshold criteria being met under Section 44. And there's the legal question, obviously, and the practical question. Legally, it would seem to us that the foster carer would be entitled to prevent the removal of the child if the removal of the child threatens the welfare. So in other words, in order to safeguard the welfare of the child under Section 3.5 of the Act. But the immediate...
You're not bothered about the subject to the other provisions of this Act
Yes,
bit?
I see that. But it does lead into a different question, if I may, and that is, what is the consequence legally of a parent saying that they want to remove their child, as opposed to the physical action of removing their child? Because in this case, the local authority seemed to draw a distinction between those two things. And it would seem to us that it must be the legal consequence of Section 28, because it is so clear and it is unqualified, that once a parent states or indicates or asserts that they intend to remove their child, that alters the status of the placement, the legal status of the placement. The question of what happens practically or on the ground is a separate question, because in this instance, the local authority has sought to rely on the fact that on the one hand, the parents asserted, first of all, to social workers, but secondly, through solicitors in writing, we are withdrawing our consent. That was the terminology that was used, and we would like our children returned to us. And we would say that it alters the status of the placement because it can't continue to be lawful accommodation under Section 20. That must be the consequence of Section 28 if it is to be read in the terms of the wording of Section 28. It's an absolute unqualified provision. That doesn't, to go back to my Lord's point a moment ago, that doesn't negate the entitlement of somebody who has care of the child on the ground to take such measures as are reasonable to safeguard the welfare of the child. If my Lord is envisaging a parent turning up at 8 o'clock in the morning and presenting some sort of risk to a child. But it's also, we would say that interpretation is also consistent with the guidance. If we go back to look at the guidance,
I thought you said that Mr. Justice Munby dealt with this to some extent.
Forgive me.
We turned it up.
He dealt with it. Yes, he dealt with it.
You said it was tab 10. In fact, it's tab 12.
Forgive me.
Which bit of it, very quickly, would you like us to mark?
He dealt with it in the sense of his identifying section 3.5 of the Act as allowing a person, be that a social worker or a medical professional who is on the ground, to take such steps as might be reasonable to safeguard the welfare of that child. So I understand.
It's tab 11, I think, isn't it? And it's at page 226, where he deals with it. But it'd be useful just to identify what he does say.
Well, the head note is extremely useful. If the head is...
Is it, in fact, at 226, paragraph 23 and 24?
Yes, my lady. There are two Nottingham cases, in two judgments in the same case, which I think may cause the confusion. So our original reference, the provision we drew the court's attention to, is 226. And it's paragraph 23 and 24, the context in which it may be helpful to begin at paragraph 21, because Mr. Justice Munby, as he then was looking at if a child is at immediate risk of harm, what can a social worker or a nurse on the ground do? And that, of course, is distinguishing between taking a child into their care. It's taking immediate steps to safeguard or promote the child's welfare. And he then goes on to make the distinction, of course, that a nurse or a doctor would not be able necessarily to do that under section 3.5 of the Act. One looks at paragraph 23 and 24, because a nurse or a doctor, and in that particular case, of course, a social worker, didn't have care of the child. So it was considered by Mr. Justice Munby in that judgment. It helps with the scenario that my Lord Wilson asked Mr. Toomey to consider, but it doesn't address the question of the lawfulness, the continued lawfulness of the placement. And I think that my Lord was asking about both of those elements. One is the practical element, what happens on the ground. The second is the lawfulness of the placement, or the character of the placement altered by the parent, either stating or giving written notice of their intention to remove. And it is relevant in this context, in this case, because the local authority has sought to rely on the fact that the parents didn't do what my Lord is suggesting can be done or may occur, namely they didn't present at the home of the foster carers, having given notice, and they didn't seek to physically remove their children. And the local authority cannot, we say, and it would be an unhelpful and incorrect interpretation of Section 28 to say that Section 28 requires the parent to physically act on their intention to remove their child. So the local authority, we would say, can't seek to benefit from the fact that Mr. and Mrs. Williams repeatedly gave their notice, made their request clear. May our children be returned to us. My Lord, I was going to take, my Lords and my Ladies, I was going to take you to the guidance, just to emphasise the point that the guidance clearly envisages the local authority in those circumstances making an application to court for an emergency protection order if necessary. And the reference for that is MS 2095. We looked at this guidance yesterday. Paragraph 2.30. And there's a reference there to wherein a parent may become unwilling to cooperate at the outset or becomes unwilling or inconsistent in attitude. And it goes on to say the local authority should reassess the circumstances and the need for care proceedings or an emergency protection order. Now, of course, in this specific case, in relation to Mr. and Mrs. Williams, what is striking is that once the local authority on the 16th of July had itself decided that the children should go home, that the risk of harm was not present to justify care proceedings, had Mr. and Mrs. Williams done what the local authority seems to suggest they ought to have done, which was to present themselves in a place where the children were and take the children home, the local authority, on its own analysis of the risk of harm at the time, would not have been in a position to make an application for an emergency protection order, because they would not have met the threshold criteria on its own analysis of the facts at the time, after the 16th of July. And that's quite an important point when the local authority seeks to rely on the actions of the parents, or if you like, the inaction of the parents following their giving notice.
I thought the plan on the 16th of July wasn't on the premise they could go back today, but that one way or another we will be able to put in hand mechanisms and protections that will enable them to go back soon.
It's part of a wider analysis by the local authority. It is part of an analysis of are we making applications for court orders? Those are the matters that the local authority is considering in the context of that discussion. And my point is simply this, that if on the one hand the local authority says Section 28 does not become effective unless you present yourself and take your children, and Mr. and Mrs. Williams not doing that meant it didn't become effective. But on the other hand, the local authority are saying we don't have evidence here to make an application under Section 31, then they also would not have had evidence to make an application under Section 44 had Mr. and Mrs. Williams presented themselves and sought to remove the children. Now, I realise there's a different point the local authority makes about the bail conditions, but just looking at it in the context of Section 28 and the question my Lord asked, what is the legal effect, as I understand it, and the practical effect of a parent presenting themselves, and secondly, what is the action or the consequence for the local authority, we would say that is the correct approach. There is either an application to court, there is a lawful protection for the child on the ground under Section 3.5, but the lawfulness of the placement, the character of the placement, is altered by the giving of notice or the statement, I want my children returned, or however it is communicated. I hope that answers my Lord's question. May I then move on to deal with an issue that my Lady Hale raised yesterday, and that relates to the question of a parent without capacity, and whether or not a local authority can lawfully accommodate the child of a parent without capacity. We find ourselves somewhere between the position of the ALC and the Family Rights Group on this, because if one assumes, and one has to, that the local authority in the first instance would have to be acting under its duties under Section 21C, which we say can obviously be engaged for a parent who lacks capacity, or its duties under Section 24, then the question becomes, can a parent who lacks capacity object? Or the point raised by my Lady Black, can a parent who lacks capacity remove their children from the accommodation? And we would say that the answer to both of those questions has to be yes, subject to the additional procedural safeguards that the Family Rights Group in their helpful knowledge inquiry identify as being of some significance when a local authority is engaging with a parent who has learning difficulties. So there has been much discussion or focus in the reported case law and in our submissions about the information which is to be provided to parents. The issue of capacity is a matter that social workers deal with relatively frequently, but it is complex because, of course, a parent can have capacity for one purpose and not for another. But as a matter of law, we would say a parent without capacity can object, if that's going to be the test that this court applies, and a parent without capacity can remove their children from local authority accommodation, in which case, once you get through the Section 21C or the Section 24, then under similar circumstances you can accommodate the child of a parent who lacks capacity. May I move on just to deal with a number of short matters that were raised in the course of submissions from other parties. On a point of information, my lady raised the question, Lady Hale raised the question of the regulations under the Act. Mm-hmm. Those are, well, there's an excerpt from the regulations in the Authorities Bundle, Volume 6, Tab 76, and it's MS 2069. The regulations were reissued or modified and issued in 2010. And we make reference to part of the regulations in our document at MS 2757, paragraph 33.
Sorry, give that again.
MS 2757, paragraph 33. That's our reference. And the regulations themselves are at MS 2069, Volume 6 of the Authorities Bundle, Tab 76.
Or do they have anything helpful to say?
Not particularly, not beyond...
Sorry, bother referring to them.
Yes, I'm sorry to say, not really beyond the excerpt that is in our document. In fact, there is far more of use to a social work practitioner, to solicitors dealing with parents who would have queries in the guidance itself. And there's an interesting point, we would say, that follows from that. Mr. Verdon this morning made reference to the fact that social workers might be more helpfully directed to the guidance because of the very clear tone and ethos of the guidance about the voluntary nature of the accommodation and the arrangements. But it's also interesting, we would say, that although the Act is silent on the point of consent, it's interesting that local authorities, from the implementation or the coming into force of this Act, have always assumed that the combination of the guidance and the Act is that you obtain consent. And it's interesting that Hackney itself, in its document, acknowledges that from the beginning, from the inception of this legislation, it has been the policy of Hackney, as a matter of good practice, to obtain consent. And that tells, we would say, something quite important about how service users read the legislation and read the guidance together. May I then move on to a different point? You should have received, my ladies and my lords, a short note headed Appellant's Supplementary Note on Bail. And this was prepared by Miss Cooper overnight to amplify, to some extent, the points that were recorded in the judgment of Sir Robert Francis at first instance. But also, my lady had asked for more detail as to the legislation which applied at the time that these children were in local authority care. I don't propose to take the court through the document. It is, in my submission, self-explanatory, but attached to the document, the court will have the relevant sections of PACE, which were in force at the time, and also a helpful document a guidance note prepared by the Association of Police Officers and a number of other bodies, which is at page 31 of your small bundle, which is a prosecution team manual of guidance, and you'll see on the top the authors at the top of the page, the authors of that. And we would direct you particularly to paragraph 1.7.3, page 37, which sets out pre-charge bail conditions, what happens when an officer in the case is considering whether conditions should be imposed. And you will see the umbrella, the third bullet point, under which the bail in this case was imposed. I don't intend to revisit our submissions that it wasn't, and this of course was the finding of Sir Robert Francis, it wasn't an inevitable consequence of a breach of the bail in this case that Mr. and Mrs. Williams would have been arrested. What it, without speculating, well, speculating to a degree, what it is likely to have resulted in was a focus on the question of whether the circumstances of the family had altered so that the bail conditions should continue. But I accept that that is a matter which was dealt with by the trial judge. It does, however, lead us on to the other point that I wanted to address briefly, which was Mr. Stewart's submissions this morning, picking up on the point that he ended with yesterday evening, as to the operation of Section 28 and the qualification that he invites the court now to write into Section 28. That being that a local authority cannot return children or cannot permit the removal of children from accommodation if to do so would result in an unlawfulness on the part of the parents. Now, the first submission that we would make... I think
he casts us rather wider than that, because he disavowed my suggestion to that effect. He says that public policy arguments, while embracing that particular consideration, might extend further.
Well, may I deal with both of those points to the best of my ability, responding to the issues raised by Mr. Stewart, because his first submission to this court, and it was a submission that he returned to during the course of his oral submissions, despite raising the public policy arguments and relying on the various authorities in that respect. But in relation to the unlawfulness, that was his, the way that he characterised the local authority's entitlement not to allow a parent to remove their child from local authority care. The difficulty, there are a number of difficulties with that submission. The first difficulty is if he is inviting the court to write in or to read in to Section 28, either a qualification that the child should not be returned because it would result in an unlawful act, or a qualification that the child not be returned on some public policy basis. Both of those things are, we would say, recipes for confusion, and they run completely contrary to the decision of Parliament not to specifically or explicitly qualify the provision in Section 28. So reading in that type of power for the local authority would effectively negate the entitlement of the parent. Bearing in mind, in this case, putting its case at its highest, Mr. and Mrs. Williams would have been in breach of a bail condition, which is not a crime. And so the
would they be acting unlawfully if they removed the children under Section 20, subsection 8, when in doing so they were in breach of their bail conditions?
Well, my lord, I don't think that we would accept that they would be acting unlawfully. The difficulty is Mr. and Mrs. Williams would be acting unlawfully under the bail conditions if they were having unsupervised contact with their children.
If they remove them from their place of accommodation,
Do you accept that they'd be acting unlawfully if they were in breach of their bail conditions? That's a really difficult question because it's not a crime, it's not a tort. The only consequence of being in breach of bail conditions is that you are subject to arrest.
You may be.
Well, yeah,
Yes.
you are subject to a power of arrest.
Yes.
If that power is exercised, you're taken back to the police station, and at the police station, the decision has to be, Ms. Cooper's going to tell me if I'm getting all this wrong, as she's researched it, has to be whether to charge with something or other, but not with that, because that's not an offence, or whether to, or whether to release again on bail.
Yes.
That's the consequence, as I understand it.
Indeed, and also whether to lift the condition in the condition which was imposed in the first place.
Yeah.
So, in terms of whether it is unlawful, and maybe a way of dealing with this is it's not entirely clear to us what the unlawfulness is that the local authorities say they were seeking to avoid, and perhaps that's why ultimately they move more into public policy.
But I mean, the question is really whether it's unlawful for the parents to breach the bail condition. First question, was it unlawful for the parents
Yes.
to breach the condition?
Well, I
I'd
don't.
have thought it clearly is. Whether the authority acting unlawfully and aiding is another matter, but I don't see, if you've got a bail condition which says you shall not have contact, I can't see why it would not be unlawful to break that.
But
It doesn't matter whether it's a
my lord,
tort or a crime.
What I think we're struggling with is what law is being breached.
Oh, the
It's
condition. It's a lawful condition which are breached. I mean, it's right. I mean, there are lots of things which are unlawful but don't necessarily result in criminal proceedings or tortious proceedings.
Well, my lord, I'm not sure that we would take the same interpretation. It is unclear, I think we would have to say, because it is not a crime, and the consequences of it
I think
are
you need
not.
to distinguish between criminal activity and unlawful activity. My Lord is putting to you, if a properly imposed bail condition is not observed by the person to whom it is directed, is that unlawful? If it's not unlawful, at first sight that seems a slightly curious situation. I mean, if you take, for instance, it doesn't arise in this case, but if a bail condition was imposed by a court and you failed to abide it, you would be plainly acting unlawfully, wouldn't you?
Well, my lord, I think that that's different because that would have.
Well, let's start with the premise. It would be unlawful if you failed to abide a condition imposed by a court.
I think I would have to accept that.
Yeah.
Yes.
Well, what's the point of distinction between a condition imposed by, under the Police and Criminal Evidence Act, by a police officer?
I think there are two differences that we would identify. One is that it is a pre-charge condition, which is imposed by the custody officer, and secondly, that the conditions, the consequences for breach are simply that a person may be rearrested. The breach itself isn't punishable, and my lord, that is our understanding of the provisions in relation to bail that we have handed up.
But why does that make it lawful? I mean, let me give you an example from a completely different field, which I know more about. Building without planning permission is not unlawful in the sense, at least it is unlawful, but it's not a crime, it's not a tort. It has consequences, which is the authority may serve an enforcement notice, which may result in your having to pull the building down. But I don't think there's any doubt that in itself it's unlawful. Just question what are the consequences of that. And so here, I mean, from my mind, breaching a bail condition is clearly unlawful. The issue of what are the consequences and what effect it has on the local authority seems to be a quite different point. Would you not accept that?
Yes, I mean, I see the point that my lord is making, yes. But, my lord, may I also, in relation to the submission of the local authority that an unlawful, in order to prevent an unlawful act, the local authority is entitled to retain care of a child in the face of the parent's request for the child to be returned or the parent's attempt to remove the child, bearing in mind that Section 20 of the Act is very clear that that is an unqualified right. The great difficulty with making a blanket assertion that any unlawfulness is going to entitle the local authority, or an attempt to avoid any unlawfulness, is that there is an issue in terms of proportionality, there is an issue in terms of consequences, and consequences are, we would say, relevant. So, you know, if a parent, for example, is parking on a double yellow line, they may be breaking the law, but is that an unlawfulness that is going to be relevant in the context of the point or the submission that the local authority are seeking to make? And it is also inviting this court to read in to the legislation a very amorphous concept which is entirely absent of any consideration of the consequences for the parent. So while my Lord Carnwath has pushed us, if you like, on the question of is a particular action, in this instance, breach of a bail condition, unlawful, it is, we would also say, relevant if the local authority are going to invite the court to interpret the statute in this way, that one looks at the consequences of the unlawfulness. And in this case, the consequences of the unlawfulness are as set out in the judgment of Mr. Justice Sir Robert Francis. So it may or may not result in the parents being arrested. It may or may not result in the condition being continued. It may or may not result in the condition being lifted entirely. And those factors are relevant if the local authority is seeking to rely on the facts in this case to make that very, we would say, dangerous submission that would result in this court reading into the legislation a provision which Parliament chose not to include in the legislation. There is no qualification of Section 28. If we then look at the public policy arguments, the great difficulty with that argument is it is a very circular argument in the context of this particular scenario. First of all, there is public policy elements that come into play when one looks at whether children should be returned to their parents, whether they should be kept in local authority care, whether they should be separated from their family. And my Lady Black asked the question of Mr. Stewart, which I'm not sure we ever returned to, when a local authority is making a decision as to whether or not it is going to return or permit the children to be returned once the parent has asserted or requested that they wish them to be returned. Is there a public policy consideration of the necessity and the proportionality of returning those children to their family? And we would say that that is something in the particular circumstances of this case, which should be and should have been very prominent in the local authority's thinking. And it goes to all of the actions taken by the local authority. In other words, we do not accept that you are entitled to request the return of your children because you are under bail condition, despite the fact that we have, at an earlier stage, decided that your children should be returned to you, and that is what we are working towards. So that is elevating the bail condition to a practical impediment, and we said yesterday seeking to rely on this technical difficulty. But I won't revisit those points because we addressed them in some detail. May I then move on just to deal with one final issue from our perspective, and that is the question of the parliamentary debates and the material from Hansard's. We, on reflection, do not invite the court to look at the minister's statement. The court has now had sight of the bill, and the court can see that the bill was in a particular form, which had no qualification also to section 7, forgive me, subsection 7, 27, but a qualification was added. But we don't say that the reasoning of the minister or the statement of the minister is of a quality or a clarity which would justify our inviting this court to look at it, nor do we say that it's of a certainty that it would resolve the ambiguity. It will be for the court to resolve the ambiguity, following on from the submissions that we have made and those that have been made.
You've probably looked at Pepper and Hart overnight. Was I right to recollect that it was said there that you could consult Hansard to look at what the mischief aimed at by a provision was thought by the government to be?
My Lord, that is part of the test in Pepper and Hart, but the starting point from our understanding is that the provision which one would be seeking to invite the court to look at would need to be of a clarity or certainty that would assist the court in resolving the ambiguity on reflection.
Well, we've all read it, DBNE essay, because we've read your case very carefully.
Yes.
And speaking entirely for myself, I find the original bill drafting very interesting. I find the amendment very interesting. And having read DBNE essay, the minister's explanation, one can see clearly what the mischief was aimed at in introducing this problematic amendment was. And it might be rather a pity if our judgments were disabled from making that explanation. But Ms. Fottrell, that's your stance, and we'll have to leave it there.
My Lord, I think the difficulty in inviting the court to look at it is that the statement itself would have to be unambiguous and open to only one interpretation. And I have to accept, the court has looked at it, it's in our document, but I have to accept that the statement of the minister was designed to address a particular mischief.
Quite.
But it could go further. Then it could be wider than just that circumstance, which was given by the minister to explain the action that he had.
Well, of course. Well, very well. Thank you.
My lords and my ladies, we didn't propose addressing the court on any further issues unless there were any further matters that we have been invited to deal with and have not.
My lady, my lords, maybe just raise one point on that last bit. As it was left yesterday, our recollection is the understanding was that if there were going to be submissions, there were submissions in relation to this issue of the bill and Hansard, that we would have an opportunity of dealing with them. There's no problem. If the position now is that, having read material DBNE essay, if the court is going to completely disregard what the minister said, then I sit down and have nothing more to say. But if there is any question of the court not completely disregarding that, then that opportunity that was contemplated for us to say something is one which, in fairness, we should be allowed to take.
Well, as may be apparent, the court may not currently be unanimous on this point.
That's why I asked the question.
But that is, of course, only a current situation, and that is easily capable of changing in either direction.
Indeed, yes.
And so I think it would only be fair, Mr. Stewart, to allow you to make your observations.
Yes, they're pretty brief, my lady. You'll be, I'm sure, relieved to. Perhaps we actually should go to it then. I think that's the easiest thing. That's at MS 2164. Where is it? So it's, it's tab 84, isn't it? So that's volume 7. Is it? It's in volume 7.
It's 2162.
Yes, 2162. I'm sorry, I've just mislabeled my volume 7. Here we are. I've got it. It was hidden under something else.
2162.
Yes. So it starts, but I'd like to go on. Your ladyships, your lordships, you've read it, de bene essay. I'll just go on to 2164, column 156, because it's really just that last point in what the minister, Mr. Mellor, was saying, that subsection 7 goes too far. And that was subsection 7 as in the original bill. So your ladyships, your lordships, you have the two versions, and they are a very simple version in the original bill, where anybody with parental rights could object, section 7. And subsection 8 was pretty as it stands now. The change is essentially the change that we now have, so that we now have subsection 7 with the qualification that you've got to be willing and able. And what the minister gave here was one example of that situation. A mother bringing up a child alone after a separation could experience difficulties and ask for the local authorities to look after the child for a short time. Of course, there's the difference there, that this is the mother actually positively asking. So obviously there's no question of objection by her. She's asking. The estranged father could block the arrangement, and he's talking about the position, of course, under the original bill, because the estranged father would have parental responsibility, and in that simple, straightforward original version of subsection 7, he could say, I object, and that blocks the local authorities' duties and powers under section 20. So the amendment, and then what Mr. Mellor said, the amendment would limit the bar on local authority providing accommodation. And there must be a slip at the next word, whether it's the preparers of Hansard or the minister. That next word must be to, because the word in doesn't make sense. We'd suggest it's just simple, obvious reading, actually. The next word must have been intended to be to. So the amendment would limit the bar on local authorities providing accommodation to cases where a person who had parental responsibility objected. And
Mr. Stewart, speaking for myself, I mean, we've read this DBNE essay, we're reading it again. There was a particular instance which was worrying the minister, hence the amendment, but of course the words go wider than to cater for that situation. Yes. I mean, that, to my mind, is pretty obvious.
We have really, in the light of that comment, of course it's just comment from one of the court, but that's our position, my lord, and we say that clearly you can't then, that amendment having been made, you can't then distinguish between cases like this one specifically.
Of course not.
And other cases.
No.
So it's all, this is, the minister's comment here is 100% consistent with our submissions in relation to subsection 7. That is, that's it really. That's our submission.
Right.
Thank you, Mr. Stewart. I think then it's only fair to ask Ms. Fottrell if she has any comment to make on that. You would both say that this is consistent with your positions, because
I beg your pardon?
you'd both say it was consistent with your positions.
Well, surprise. We should say that, but
I think you both say it's not admissible anyway.
I'm just proceeding on the basis that it might turn out to be. My lady, we still, I'm afraid, haven't got that leaflet.
Well, if a leaflet produced in response to the Ombudsman's recommendation that you should do so emerges, can be found, well, I'm sure we would all like to have a look at it.
Well, in that, we will find it as soon as we can, my lady, and we will submit it through the usual channels.
Splendid.
Yes.
As so often happens in this court, the arguments range rather wider and sometimes more deeply than have the arguments in the courts below. But that, of course, does not diminish the great interest with which they've been listened to by every member of the court. We're most grateful to you all, those who've been on their feet, and those sitting beside those who've been on their feet, and those sitting behind those who've been on their feet. I hope that Mr. and Mrs. Williams, and I imagine one of the children involved is also in court, yes, because it's all so long ago that you're now grown up, yes. I hope you realise that these are points of law of very general public importance that matter to a lot of people, and that is why we are discussing them here. In a way, it's not personal. I'm sure you understand that, and that we are now going to go away and do our very best to find out some sensible answers, and we'll let you know those answers in due course. You may be asking for more than we are capable of giving you in terms of really clear, consistent guidance about absolutely everything. But we'll do our best. Thank you. Court is now adjourned.